Yes.
(46).
Yes.
Issue a writ of mandamus. 45 got. Hello, Justice Anjali.
Issue mandamus, yes. Page 46.
Mandamus directing the CBI to register FIRs and investigate the entire incident in relation to the obstruction of ED's search conducted on 8th of January 26 at both the residential premises of one Mr. Pratik Jain as well as the office of Indian PAC Consulting Private Limited I-PAC, described in detail here above, including the role of the present respondents number 2 being the Chief Minister of West Bengal, Commissioner of Police, Calcutta, Director General of West Bengal Police, other police officials, and all persons acting in concert. So, well, as your lordships will have to find, as a matter of fact, that the ED has a fundamental right to seek this prayer. Because ED is the petitioner, brothers. So,
Yes.
an entity has a fundamental right to seek a prayer under Article 32 for the purposes of another agency of the central government to investigate a matter. It's a proposition of law, brothers, that has not been canvassed and upheld in any court so far. 2. Direct immediate seizure, sealing, forensic preservation, and restoration to lawful custody of the Enforcement Directorate, all digital devices, electronic records.
It can be a little more loud, but voice is not coming.
Oh, I'm sorry. I thought I'm normally loud, but I'll be louder. Direct immediate seizures.
Not for him, he says.
Well, he is such a gentleman that he seldom hears.
No, they need, and they want you to be more. Yes.
Direct immediate seizure, sealing, forensic preservation, and restoration to lawful custody of the Enforcement Directorate, all digital devices, electronic records, storage media, and documents illegally and forcibly taken away from the search premise. Then see, issue a writ of mandamus commanding the respondent number 1 to 5 authorities, restraining the state authorities from interfering with the proceedings under the MLA. Now, this is a different kind of prayer. The first 2 prayers are a mandamus, brothers, as to who should investigate the matter and whatever documents according to them were taken by them, return those documents. But C is issue a mandamus commanding the state authorities from interfering in proceedings under PMLA, restraining the state authorities from interfering in proceedings under PMLA, and transfer FIR number 3 registered in Shakespeare Sarani, whatever. Dated 8th of January, registered in Electronics Complex, and any other FIR registered against any officer of the enforcement with respect to searches conducted on 8/1/2026. Now, brothers, this is a prayer seeking, brothers, that the FIRs registered on the basis of the conduct of the ED officials, those FIRs, brothers, should not be proceeded against. And, brothers, those annual lordships have already stated them. So, brothers, this is on the premise, brothers, that if an employee of the central government or an officer of the enforcement agency commits an offense within the jurisdiction of a political police station in a state, then, brothers, that offense cannot be investigated. This is on that premise, right, brothers? Luckily for us, we have a judgment recently by this court, brothers. Justice Parliwala judgment. Can you just read it? It just happened the other day. Level Kishore. Mullah, I tell your lordship the brief facts in that judgment. Mullah, an officer was alleged to have sought a bribe. Officer of the central government was alleged to have sought a bribe, Mullah. And he was sought to be prosecuted, and he was an employee of the central government in the state. And the question arose before the court, can he be prosecuted? Because he's an employee of the central government. And Justice Parliwala held, yes, he can. Merely because he's an employee of the state, it really doesn't matter. So the proposition is that an offense is committed by the state by an officer of the central government in a state where the situs is within the police station jurisdiction of that police station, that investigation must go on. Right? So that's what it is. But you have to get to this. What even told them?
You mentioned the citation will write it. We'll take a note of it.
2026 SCC online. What sent it to him? 2026 SCC online, Supreme Court 103. And the cause title is Naval Kishore Meena versus State of Rajasthan. Paragraph 6 and 7. I read it.
Yes, please. Yes, please.
Section 156 of the CRPC, falling within Chapter 12, deals with powers of the police officers to investigate cognizable offences. Subclause 1 of Section 156 says that any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of Chapter 13. Subclause 2 of Section 156 of the CRPC says that no proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Section 4 of CRPC deals with the trial of offences under the Penal Code and other laws. Subsection 1 of Section 4 says that all offences under the Code shall be investigated, inquired into, tried, or otherwise dealt with according to the provisions of the Code. Subsection 2 of 4 of Section makes it clear that all offences under any other law shall be investigated, inquired into, tried, and otherwise dealt with according to the same provision, but subject to any enactment for the time being enforced, regulating the manner or place of investigating, inquiring into, trying, or otherwise dealing with such offences. The Code of Criminal Procedure is the parent statute which provides for investigation, inquiry into the trial of cases, and unless there is a specific provision in another statute to indicate a different procedure to be followed, that's a different procedure to be followed, the provisions of CRPC cannot be displaced. In other words, the existence of a special law by itself cannot be taken to exclude the operation of CRPC unless the special law expressly or impliedly provides a separate provision for investigation. The general provision under 156 shall prevail. Now, the PC Act is a special, now it goes to the issue. The PC Act is a special enactment enacted to deal with the bribery and corruption. Going by Section 4.2, read with 156, the provision of CRPC shall be applied to the extent that they are not inconsistent with the provisions of the PC Act, which being a special act, will deal with all kinds of offences committed under it. Section 17 of the PC Act deals with investigation into cases under the Act. It is extracted here under for easy reference. Then Section 17 is extracted, I won't read that. Then let's straight away, they refer to the PC Act. The PC Act does not specifically envisage a separate procedure for conducting investigation. The offences under the PC Act can be investigated into by the state agency or the central agency or by any police agency, as can be seen from Section 17 of the said Act, with the qualification that the police officer shall be of a particular rank. Section 17 does not exclude or prevents the state police or a special agency of the state from registering a crime or investigating cases relating to bribery, corruption, and misconduct against central government employees. So you can register a crime if a crime is committed within the jurisdiction, even if it is a central government employee. It is for the convenience and to avoid duplication of work that the CBI, a specialized investigating agency under the Special Police Establishment Act, is entrusted with the task of investigation of cases of corruption and bribery against the employees of central government and its undertakings. And the Anti-Corruption Bureau, a specialized investigating agency of the state, is entrusted with the task of investigation of cases of corruption and bribery against the employees of state government and its undertaking. As stated above, Section 156 of CRPC authorizes any police officer in charge of a police station to investigate a cognizable offence without the order of the magistrate. The word police station has been defined in Clause S of Section 2 of the Code to mean any post or place declared generally or specially by the state government to be a police station and includes any local area specified by the state government in this behalf. The Vigilance and Anti-Corruption Bureau is also a wing of state police. The offences under the PC Act are also cognizable and can therefore be investigated by the state police or DACB, that is the Anti-Corruption Bureau. The only rider is that the investigation can be done only by a police officer of the rank specified in Section 17. As per Section 22, therefore, the persons of CRP, provisions of CRPC shall apply, save and except the specific areas envisaged by the Act. A similar question came up for consideration before this court as early as 1973. That was the case where a crime was registered against the accused under Section 5(2) of the PC Act by the Anti-Corruption Department of Delhi Administration. After an investigation, the final report was filed. The accused was tried before the Special Judge Delhi, and he was convicted and sentenced to undergo imprisonment. His appeal was dismissed by the High Court. He challenged the conviction and sentence before this court. The main ground urged by the accused before the court was the Delhi Special Police Establishment Act, as amended, prescribed special powers and procedure for investigation of offences of bribery and corruption in the departments of the central government. And as he was an employee of the Central Works Department, and offences against him could only be investigated by the SPE, established under the DSPE Act. The investigation having not been done by the Delhi police, his trial was vitiated, contended the accused. This court, after evaluating the rival contentions, held that the scheme of the Act does not either expressly or necessarily, by necessary implication, divest the regular police authorities of their jurisdiction and power and competence to investigate into offences under any other competent law. It was further held that the DSPE Act seems to be the only permissive or empowering, intended merely to enable the Delhi Special Police Establishment Act also to investigate into the offences specified and contemplated by Section 3 without impairing any other law empowering the police authorities to investigate offences. The Central Bureau of Investigation has also been constituted by notification. And then ultimately the court held that the state can. Now, in this case, an FIR has been registered for cognizable offences that have been committed within the jurisdiction of a police station. And therefore, to say that cannot be investigated, be contrary to the law laid down by this court, and I request your lordships that stay should be vacated. So that's on the prayers that I mentioned. Now, kindly, we were talking about the fundamental right of the Enforcement Directorate. My learned friend, Mr. Diwan, has already amply argued that matter most effectively. So I'm not going to waste your time on it. But kindly have a look at the petition and the cause type. Now, kindly have Now, kindly see the cause type of this petition. Kindly see. Now, kindly see. Directorate of Enforcement being represented by Deputy Director. Just mark that. Being represented by Deputy Director.
Yes.
Directorate of Enforcement, New Delhi, having its office at Pravartan Bhavan. And Robin Bansal, son of Rakesh Bansal, aged 38, currently working as Deputy Director. So, he is the Deputy Director through which the petitioner number 1 is moving. And Rakesh Bansal is the Deputy Director who is currently working. Now, this Deputy Director was nowhere. He was nowhere in the scene. He was nowhere in the scene, Part of this petition right. This is enforcement of a fundamental right. So this is not a public interest litigation. A person, who moves the court under Article 32 has to specifically set out which fundamental right of his has been violated. Right, Manoj?
Yeah.
A person who is not on the scene, who is not at the premises when all this allegedly happened, can't espouse the cause of alleged fundamental rights of others. At least, Madam, as a proposition of law, I have not heard of this.
Yes.
That a person in a habeas corpus petition, yet the wife can file notice. But there is not a reference to the presence of the deputy director in the entire petition.
19.1 then? Yes.
Now, whereas what he has done is authorized other officers to go there.
Hmm.
Right?
Yes.
That's only an authority given by him. And your lordships will see it throughout. There is no reference to Rakesh Bansal.
No, he is Robin Bansal.
Robin Bansal. Yes. Son of Rakesh Bansal. Yes.
He was not there on the spot.
No, he's not there on the spot.
On the date of incident, whatever.
He was not there. But he was doing good for others because his name suggests it's Robin Hood.
Well, he is only Robin.
He's only Robin, unfortunately.
Minus Hood.
Yes.
Factually, there are some. I will point out factually what is the position. He may say that he was not present, but I have something to add.
No, if you mention which paragraph he is present, you have mentioned it is his petition.
I will point out.
No, if you say, if I am wrong factually, I will say.
Maybe a shadow officer.
I'm sorry?
Maybe a shadow officer.
Nowadays, there's lots of shadows going around nowadays. Yes, we just hand over that judgment, that I started. Because this is very important, from the point of view of the very basis of this petition.
Yes. This you have already read, na? This Naval Kishore.
Yes, I've already read, I pointed out those paragraphs also to your lordship. Paragraph 6-7.
Yes, yes. 6-7, yes. We have noted para 6-7.
Paragraph 7, 9.
9 also? 9 and 10.
7, 9 and 10. 9 and 10. That's very important.
Yes.
So, the one other submission that I'm making is that the person who has filed the petition has not claimed any fundamental right. Not only that, assuming whether I have a fundamental right. Let's assume for a moment. Then whether the petition must state which fundamental right has been violated. To the petitioner, not to anybody else. So there are two steps to be followed. One, I have a fundamental right. Two, which right has been violated? That is my right. The right of the petitioner. Both are missing.
Yes.
Right. Now, the second issue. I will cite the judgment, your lordships. State Trading Corporation versus Commercial Tax Officer. I hope you have that. This is 9 judges, In that case, the State Trading Corporation moved the court under Article 32. And the question arose as to whether they can move the court by claiming that there is a fundamental right. Your lordships may see the questions. The two questions are set out at page there are no pages here.
Very first paragraph. Very first paragraph.
Just will write him in the beginning. Justice Sinha's mothers. Okay. Oh, I see. All right, page 3, yes, right on top. Now let's kindly see whether the State Trading Corporation, a company registered under the Companies Act, is a citizen within the meaning of Article 19 of the Constitution and can ask for the enforcement of a fundamental right guaranteed to citizens under the said article. And 2, whether the State Trading Corporation, notwithstanding the formality of incorporation under the Indian Companies Act, in substance, a department and organ of the Government of India. Well, let's just pause here. This is exactly what is being sought to be argued. Department and organ of the Government of India, with the entirety of its capital contributed by the government, and can it claim to enforce fundamental rights under Part 3 of the Constitution against the state as set out as it should be in Article 12 of thereof. Now, the 9 judges, Madhas, answer this question, rejecting, Madhas, the enforcement of the fundamental right of state trading corporation, saying that there is no such right. Now, Madhas, kindly come to page 35. You see that page, Madhas, right on top of the small printed.
Which page?
Page 35. Right on top, you will see, Madhas, if you notice, right on top, there's a little small, after SEC online under that, page 35. You're on the left side.
The headnote side.
You must request this SEC online publishers
Yeah,
to print this page number,
correct.
some different place.
Yes.
You can speak to them. Because every time SEC online is cited, we need at least 1 minute to search where is the page number.
I know. And it also strains the eyes, Madhas.
Yes, yes.
Small.
Mm.
Anyway, at the bottom, paragraph, this is not to say, at the bottom of 35,
Yes.
this is not to
This
say
is
that
not to-
corporations have not been given any protection under our Constitution. Unlike the Constitution of the United States of America, our Constitution does not overlook corporations. The General Clauses Act is applicable to interpret the Constitution, and that Act, as has been pointed out already, defines person as including corporations. The following articles of the Constitution employ the word person, which applies equally to individuals and to corporations. So when it comes to Article 14, Madhas, a person can invoke Article 14, and a person will include a corporation. But that is where an act against the state, Madhas. That will not apply here. If the state does something, Madhas, then of course, the corporation can say, 2, Article 20, in respect of conviction for offences. Of that, whether the companies are convicted under some special statute. So they will have a right, Madhas, to move. 3, freedom as to payment of taxes for promotion of any particular religion. And compulsory acquisition of property. So, Madhas, except in these 4 cases, Madhas, even a person cannot move. Right? Even a person cannot move. A person cannot move under, well, it's 19. He has to be a citizen. Corporations are not citizens. So 19 doesn't apply. In this case, 14 doesn't apply. In this case, 20 doesn't apply. And the argument is 21. Deprivation of liberty. That's the other argument. They say 21, 14, 21 and 22 is what they say. That's set out, Madhas, in paragraph. I'll show that straight away from the petition. So
No, there is no paragraph.
there is a paragraph on this in the petition.
So in the petition, I saw it in the judgment.
What is the fundamental right, Madhas, that they are claiming? Page 40, Madhas.
14, 19, 21, these 3 they are claiming.
No, Madhas, they are claiming 14, 21 and 22. 19, Madhas, they can't. Individual, yes. For that, I've already given the answer.
Yes, 14, 21, 22.
And Madhas, even to an individual, Lordship may know that, the individual only can claim the right where his fundamental right has been violated. Madhas, there may be 10 people involved, Madhas. If I come to court as Robin Bansal, then I must say what is that right of mine, which is a fundamental right which has been violated. I can't talk about others. That is beyond the petition. So even if Robin Bansal were to be taken as a petitioner, only his case will be examined by the court. The court will not examine the fundamental rights which have been breached by anyone. And you have none of this here. And so, Madhas, your losses will be para 40.
Yes.
Because the impugned acts violate the fundamental rights of the officers of enforcement.
Para 40 of this?
Para 40 of the petition. Sorry, page 40, sorry. Page 40 of the petition.
Yes.
Fundamental rights can always be person-centric.
Sorry.
Fundamental rights are always person-centric or citizen-centric. They can't arise in abstract situation, in the
Yeah.
context of situation.
Yes, absolutely.
They can arise.
Yeah.
Fundamental rights can arise in context of a situation. In abstract, need not be a person-centric always.
No, Mother, I'm sorry, Mother, that is interpreted by this court by 9 judges now, Mother. Only in respect of these 4 articles.
Say rule of law. Is it not a fundamental right to have a rule of law in general?
Yeah, but if I say there's a violation of a rule of law, I have to say which violation? No, I'm not disputing what my lord is saying. If you say there's been a violation of the rule of law, the next question is which violation? Next question, whose violation? Then what are the material particulars of that violation?
That is contextual.
I'm only talking about that. What's the context here? I'm not disputing what my lord is saying. Rule of law is reflected in what? In Article 14, Article 15, Article 16, Article 19. They're all part of the rule of law. I'm not disputing any of that. Of course, they can be enforced. Question is who can enforce them? 19 can only be enforced by a citizen. Can you say it can be enforced by anybody?
In the larger context, the basic features which are carved out in the case 1 and part, are they not a kind of fundamental rights?
But that is basic feature for protection, Malad.
Then
That is the basic feature of the Constitution. Whereas federalism is a basic feature of the
so
Constitution.
in that context, the right can arise.
But how does this arise, Malad, in this case?
That is a different thing.
But I'm only talking about this case, Malad.
That's it.
I mean, tomorrow, Malad, for example, if a gas tragedy takes place like it took place, Malad, in Bhopal, then there's a parents' patria jurisdiction available, Malad, their fundamental rights, but then they can't move the court. Therefore, a parents' patria jurisdiction is there. Because millions of people or thousands of people or lakhs of people who've been affected by the Bhopal gas tragedy had no capacity to move the court. So the court takes over and Malad, the spouse is their cause. You're right. So that's not this case. So your lordship is right on the fundamentals, but you have to apply the fundamentals to the facts.
That is what we are deciding with the help of all of you.
That's precisely I'm trying to help with this. It is my endeavor to help. That's the whole point of this. I was at the moment saying the Supreme Court has not finally decided that these are the only 4 articles, 14, 20, 27, and 31, where persons is entitled to invoke the jurisdiction of the courts. So, and of course, in this particular case, mothers, the Department of Enforcement is not even a person. That's the other problem. Department of Personnel is not even a person. And that I indicated to your lordships last time, why it is not a person. Mr. Devan has already said that it has no seal, it cannot sue in its own behalf, but that's a separate issue. But I'm going to raise another argument. But the Department of Personnel is not even a department of the government of India. It is a directorate of enforcement, which comes under the Finance Ministry, the Revenue Department of the Finance Ministry. The Directorate. That's how it's claimed also in the petition. Directorate of Enforcement, not a department of the Government of India. State Trading Corporation said that even a department of Government of India cannot file a petition, but we are talking about a Directorate of Enforcement. Number 2, that your lordships may note. That the appointment of all the officers, even the Deputy Director Robin Bansal, is by the central government, not by the Directorate of Enforcement. So, Manoj, if any right has been violated, either Robin Bansal himself or the central government is the aggrieved party, not the Directorate of Enforcement. Now, why have they made Director of Enforcement the petitioner? Because the central government can't move under 32. They can only move under 131, which argument has already been addressed. The lordship must note that the appointment is only by the central government. So if a deputy director appointed by the central government is aggrieved, then either the central government is aggrieved or the individual is aggrieved. So if at all, Manoj, a petition can only be filed by the central government, but that can't be filed under 32, nor under 226. Anyway, so and another place they have said that a right under 14 is violated. That's the other.
40 and 41.
14.
40 and 41.
No. Their fundamental right, apart from 21 and 22, also 14. They have alleged that their right under 14 has also been.
There are
25.
There are 2 places.
Yes, I'm just showing that.
Yes.
25.
First at page 22 also. 22 clause.
14, 21 and 22, as I mentioned to you all.
Yes. And then page 40 and 41. Again, they have mentioned what are the rights violated.
That's right. That's 21 and 22 again.
Yes. And then next page, top of paragraph, page 41,
Yes.
they have mentioned 14 and 21 again.
That's right. So I am myself saying that 14, 21, 22. Those are the three rights that they are talking about. And 14 is against the state, Madam, so that question doesn't arise. And 20 and 21 and 22, Madam, again, those doesn't arise. But for the simple reason that the third aspect, Madam, which your lordships might consider. Yes. Now, Madam, there's after the state trading corporation, because it was a 9-judge judgment, and they answered the two questions. Well, actually, they answered only the first. Justice Hidayatullah, which judgment I did, answered the both questions. The matter was sent back to 5 judges. And that's this judgment, Telco versus State of Bihar. Just give it to my lord.
Yes.
My lord, got the judgment?
Yes.
Now, let's kindly come to page 13, Madam, at the bottom. Last 3 lines.
Yes.
Last 3 lines.
Yes.
Once a company or a corporation is formed, the business which is carried on by the said company or corporation is the business of the company or corporation and is not business of the citizens who get the company or corporation formed or incorporated. And the rights of the incorporated body must be judged not on that footing, on that footing, and cannot be judged on the assumption that they are the rights attributed to the business of individual citizens. Therefore, we are satisfied that the argument based on the distinction between two rights guaranteed under 19(1) and G and the effect of their combination cannot take the petitioner's case very far when they seek to invoke the doctrine that the veil of the corporation should be lifted. That is why we have come to the conclusion that the petitions filed by the petitioners are incompetent under 32, even though in each of these petitions, 1 or 2 of the shareholders of the petitioning company or incorporation have joined. They said, look, the shareholder has it right, certainly he is the shareholder of the company, and therefore he can sue under 19.
No, but that is not your submission. That was not your submission. You say that Mr. Diwan says it is not a body corporate. It is neither a company.
Yeah.
It is neither a department of the government,
Correct.
according to you.
Correct.
So this judgment is in terms of a company or an incorporated body.
Alternative
That is not your case. Because you say it is not a company, not a body corporate. It is neither a government.
I am not.
It is only a directorate of the government.
I am giving an alternative submission, brothers. My defense has argued on that. I'm not going to repeat that. I support that. But I'm giving an alternative submission. In any event, brothers, they cannot sue. Then you can't impede, brothers, an individual in this case when you are moving through the Enforcement Directorate. I didn't argue the point of the fact that under the Act they are appointed by the central government. Right. I'm only saying, brothers, here, if at all, it is the central government that can be aggrieved. And the central government can't move under an individual because the central government itself cannot file a 32 petition. So therefore, how can it move under an individual? And if you accept what Mr. Devan has said, that there's an enforcement directorate, it's not a department of the government of India, in any case, it cannot move them. The fact that there's a petitioner number 2 doesn't make a difference for us. That's the point that I'm making here. So it's not,
you see, you cannot equate the petitioner number 2 with a shareholder. That is what we are doing.
No, I'm not equating. No,
By reading this, you are trying to make out a point that since if the company cannot maintain, shareholder cannot maintain, therefore, if petitioner number 1 ED cannot maintain, officers of the ED also cannot maintain, that is your submission in.
No, I think I misunderstood. I'm saying in this case, it is on a higher footing because the shareholder is a citizen of India. The shareholder is a citizen of India. He is now claiming that forget about the corporation, I can't move under 32. I, as a citizen of India, can.
Yes, we have taken it.
That's all I'm saying.
Yes.
I'm not saying anything different. So now I finished with this. Then let's finally come to. Now let's on the proposition, that they say that the CBI, that the case being investigated in West Bengal should not be investigated by the state police. Right, Mullahs? Now that is covered by several judgments of this court. And your lordships may just note those judgments. And I'll give them to you. There is Sakiri Vasu, which is 2008 to SEC 409. I'll give those judgments to your presently. 409, paragraph 131. No, page 131. Oh,
Para or page what?
no. Para is 26, 27, 20, 25, 26, 27, 28. Just give. The proposition is the following. Well, let's leave these judgments out. Proposition is the following. I have a remedy. If any of my rights have been violated, I have a remedy under law. What is that remedy? I can move the magistrate. If an FIR is not being registered, I can move the magistrate. Magistrate can direct a 156 thing, as your lordship knows. Magistrate, if supposing that is it, somebody is aggrieved by that, you can file a 226. In 226, the court has ample power to pass any orders for the purposes of investigation. Even the officers of investigation can be decided by a 226 petition by the court itself saying, look, I'll have it investigated in this way or that way. I'll have an SIT or I'll have certain officers, which has been done several times, both in this court and otherwise. So, there is a remedy available. So, what is this 32 petition for? There is a remedy available in law. So, why do you have to file a 32 petition? The second judgment is Romila Thapar versus Union of India. I'll just give you also the pages.
Yes.
That is 2-1. I'm giving you lots of the citation. You hand it over. And there the paragraph is para 30. And then there is CBI versus Rajesh Gandhi.
Romila Thapar is page para 30.
30. Just a minute. Read it a little bit. Rajesh Gandhi. In that paragraph, what is? Don't, okay. Leave it, Mother. My answer here.
Para number of Rajesh Gandhi.
Mother, actually, of all that para 30 says, the consistent view of this court is that the accused cannot ask for changing the investigating agents or do an investigation in a particular manner, including court.
Yes.
The principle that your lordship are
Yes.
I don't have to cover your lordship with that. Now, let's kindly see. Now, the next proposition is Article 32 cannot be invoked for enforcement of statutory rights. There is a statute. In terms of the statute,
CRPC.
sorry.
In terms of CRPC.
Yes.
156 3 PS CRPC.
No, even otherwise, if there's a particular statute which says this is going to be the mode of investigation, you must go under that statute. Right, Malas? Now, in this context, I'm going to show some judgment, but in this context, brothers, kindly see section 66(2) of the PMLA.
Yeah, PMLA. Yes, 66(2). Yes.
Yeah. If the director or other authority specified in subsection 1 is of the opinion, on the basis of information or material in its possession, that the provisions of any other law for the time being enforced are contravened, then the director or such authority shall share the information with the concerned agency for necessary action. Right. Now let's see the petition for a minute.
Which is this agency, concerned agency?
The state police.
Hmm?
The state police, wherever the offence is committed. Well, let's kindly see. Let's let's elaborate the proposition. Unless I go into a state or I'm investigating proceeds of crime. Already investigating proceeds of crime in respect of a predicate, after a predicate offence has already been registered. In other words, because proceeds of crime only come after an FIR is registered. So, the deputy director of the director, goes and investigating a matter in which an FIR, where proceeds of crime in which an FIR is already registered. He finds that some other offences have been committed.
No, it is not some other offence. It is only in respect to 66(1)(1).
Yes, I'm saying one is the same.
Two is referable to 66(1).
No, that's right. But
That concerned agency,
no, please, let's read it.
concerned agency means agency which is referred for this.
I'll read it presently. The director or any other authority specified by him by a general or special order in this behalf may furnish or cause to be furnished to any officer or authority or body performing any functions under any law relating to imposition of tax. We're not concerned. Leave that out. 2. Such other officer or authority or body performing functions under any other law as the central government may, if its opinion, it is necessary to do so in the public interest, especially by notification in the official gazette. In this behalf, any information received or obtained by such director or any other authority specified by him in the performance of their functions under the Act as may be, in the opinion of the director or other authority so specified by him, be necessary for the purposes of the officer or authority specified in subclause 1 and 2.
It doesn't apply this.
Right?
66 has no application.
No, but it has been decided in this court. I said no.
It has no application.
Please read it with me.
You have read it.
If you're also,
Prima facie, we are of the view that it is not.
I'm trying to show to you
Yes,
that prima facie that's not.
Yes.
If the director or any other authority specified in subsection 1, not 2, is of the opinion. 1, kindly read 1. 2 doesn't apply. 1 is an officer or authority or body performing any functions under any law relating to imposition of tax, duty, or cess, or to deal in foreign exchange, prevention of illicit traffic in narcotics, drugs, psychotropic substances, under the narcotic drug and the psychotropic substances. Right, Manas? It is only in these questions. When he is investigating this, when he is investigating a psychotropic substance case, if the director or other authority specified in subsection 1 is of opinion on the basis of information or material in its possession, that the provisions of any other law, that is the other than the psychotropic substances, other than illicit traffic, other than foreign exchange, please appreciate it has nothing to do with 2. And it's settled law. Your Lordship, I'll show that. That's the case. I'll show to your Lordship any number of judgments. So if he's investigating a case under tax, or he's investigating a case for duty or cess, or dealing in foreign exchange, and he finds that some other offense has been committed, he has to go to the state machinery. That's the law, mothers. They are here in, I hope, mothers, I'm making my point. They are here investigating what? Proceeds of crime in respect to what? Both scam, for which an FIR is registered. In the course of that investigation, they find that some other offense has been committed. Under 66(2), they have to refer it to the state. Right? And what are those other offenses? Just see the petition.
You want that if the CM barges in and CM commits any offense, the ED will inform the state government, which is headed by the CM. If the chief minister barges in, commits an offense, obstructs the ED, the ED what is required to do according to your submission is that ED will inform the state government whose chief minister has barged in. That is your argument. We have understood. We have understood your argument.
Lordships are getting upset for no reason.
No, I am not.
Let me explain.
We are just trying to explain you that we have understood it.
No, your Lordships haven't. Because your Lordships are now saying, you're assuming that the CM has committed offences.
No, we have not.
You are.
That is the fact.
Well, how is it the fact? It's an allegation.
That is allegation.
So don't say it's a fact, Manoj.
Yes, you are right. It's
That's all I'm saying, Manoj. There's nothing more. Once your Lordship
These are the-
once or twice,
Don't mistake us, Mr.
it's an allegation.
Allegation on us.
No, it's an allegation by them against the Chief Minister.
Yes, that is the
Not a
allegation.
fact.
And that is,
Which is published every.
because of that, we are here, all of us are.
Honorable Chief Minister comes on the media and says
Not
that
a
yes,
fact.
I have collected every evidence which is gathered by the.
It is not a fact, is what I'm saying. It's an allegation.
Yes, it's an
So
allegation.
you can't assume that
Allegation is always based on some facts. If there are no facts, there is no
That is
allegation.
to be investigated.
There has to be some factual foundation
That is
for every allegation.
That is to be investigated.
Yes, and that is what they are praying for.
For CBI to investigate.
Whatever agent,
No, that's
that is
the
their
point.
prayer.
The point I'm making is 66(2) doesn't allow them to do that.
Yes, please. We are just trying to
Yes, I-
apprise you what we have gathered from your argument.
Whatever I'm trying to interpret 66(2).
No. You are trying to say that when any offense is committed,
Yes.
while investigating if the PMLA investigation is underway and some other offense is come to the notice of the ED officers,
Right.
then the concerned agency,
Yes.
in this case,
Yes.
state government
Yes.
should be informed.
Yes. Now, let me explain. Forget the CM for a minute. We're interpreting.
No, I have not said against CM. Since you are accusing that the moment we say CM,
No.
we are assuming something.
Sir, I'm just.
The second time I have not mentioned.
No, I'm not saying this, Manoj. Now,
Yes.
assuming Manoj, an ordinary person, an investigation is taking place for us, and somebody finds that an offence under the IPC has been committed by an ordinary person, 66(2) will apply. 66(2) will apply.
Yes, you argue.
That's the point I'm making, Manoj.
Yes, please.
Forget about authorities. At the moment, I'm saying 66(2) provides provides a provision under the PMLA that if number 1 applies, that is subsection 1 applies, and during the course of investigation, right, an offence is committed, then it must go to the state agency. Now there is a case, Manoj, which has come to this court in respect of a Deputy Chief Minister of Karnataka, where during the course of a tax raid, Manoj, it was found that certain other offences have been committed. Right, Manoj? That was referred to the state agency. That was objected to.
Yes.
I think my lord is also aware of that.
No, we are not aware.
My lord is aware. My lord is aware because he
Here
was.
the questions are on a far larger scope in this petition. You are arguing 66 all right, but the questions here involved are on a far larger.
I am not disputing that at all.
The allegations are true, then it's directly strikes as the rule of law.
No.
It is Article 14.
That is the article.
1 second. Just we come to
This
that.
is what.
Well, sir, at the moment, what was I interpreting? 66(2). I was not talking about this. Well, I was interpreting. My lord said 62 it doesn't apply.
These questions are important. You may be right.
Yeah.
Then the questions.
That's right. I answered that, Manoj.
Here very on the last.
I had answered that, but at the moment I was only answering one small question. Your lordship said 66(2) doesn't apply. Your lordship said it doesn't. I was only answering that, Manoj. I was only answering that question, that 66(2) apply. Your lordships put to me another question altogether. You are saying even if 66(2) were to apply, this has a much larger ramification. It's what my lord is putting to me. I understand that.
The very nature of the controversy raised in the 32 petition.
Yeah.
It is a very higher and a very higher petition.
I agree, Manoj. I am not disputing that. I was at the moment when I was talking.
Very aspect to be seen in that.
That's correct. I will answer that, Manoj. I will answer that. I was just answering
And
this.
why 66 may not apply is, we are asking the question, not that we are assuming something.
Yes, sir.
If you don't ask any question,
No, please do.
keep quiet,
Yes, no, Manoj. How?
and then deliver a
How will
judgment,
I answer, Manoj?
then you will,
Difficult.
anybody,
True.
it's difficult.
Please ask.
What we have understood that, you see, there are two distinct allegations.
Right.
PMLA allegations at the first place,
Right.
which ED is inquiring.
Right,
That is one set of allegations and one set of offences.
correct.
And this particular allegation
Yeah,
is a separate set of offences.
right.
This offence, the second set which the petitioners herein are alleging, that has not been committed in continuation of or while the investigation of PMLA offence was undergoing.
Yeah,
There are two distinct offences.
right.
While PMLA offence is going on, PMLA officers have not unearthed or come across some other offence. The present is an offence in which is committed by some other persons against PMLA investigators.
Your lordship is right. Your lordship-
Therefore,
what your lordship
it would
is-
not apply.
Yes, what your lordship is saying is that here the offences have been committed against those who were investigated. That's what my lord is saying, right, Malas? We'll accept that prima facie to be correct, Malas. We'll accept that. Now, Malas,
No,
let's
why
see.
shall you accept when we say
No,
there are-
prima facie. Since your
when
lordship.
we say it is facts, you object to it.
No, I'm not.
And now you are
Malas,
accepting that.
I'm taking the argument forward. Malas.
Anyway, please proceed.
Malas, if I don't take if you ask me question, I don't take the argument forward, the same thing
It
will
will
happen.
exactly apply to
The
us.
same thing will happen, Malas, if you don't ask the question. Now,
And we ask the question, don't
see the offences.
don't think that we are agitated.
Kindly see, Malas. Kindly see.
And don't agitate us by saying that we are agitated.
I'm not agitating you. Malas.
No.
Kindly see section page 38.
Yes. Page
38.
yes.
Abetment, criminal conspiracy, voluntarily causing hurt, wrongful restraint, wrongful confinement, force, criminal force, assault on or criminal force, obstructing public servant in discharge of public functions, omission to assist public servant when bound by law, disobedience to order during promulgated, theft in dwelling house, theft after preparation, robbery, dacoitry, criminal trespass, house trespass, destruction, all that. These are the offences that are alleged to be committed by the officers of the state. That's the allegation, right?
Yes.
Now, Mallards, these offences have been committed. I'll assume, for the sake of argument, I'll assume. What is the fundamental right to move? If a person has been kidnapped, Mallards, let's assume, person is kidnapped. While he is kidnapped, he can move under 32. But if he has been released, he can't move under 32. In the light of what my lord put to me.
No, I was putting it in the context of 66, not in the context of 32.
66, whereas even 66, these offences cannot be investigated by an authority outside the police station where they were investigated. That's the code itself and the BNS. Any offence committed, Mallards, within the situs of a particular area has under the law to be investigated by the police officer. That is Mallards, settled law. It can't be investigated outside. It can be investigated outside only pursuant to a 226 petition. Or a transfer petition. What my lord was saying to me is absolutely right, that there's a larger issue. There's no doubt about it. But what I'm saying is entirely different. The law cannot change because there's a larger issue.
Now, yes, according to Article 32 would not apply merely because there is a larger issue. Article 32 petition is not maintainable merely because there is a larger issue. That is your submission.
I'm saying, Mallards, 32 petition is otherwise not maintainable. I'm not on the facts at all, Mallards. I have indicated to your lordships how 32 is otherwise not maintainable. But 32 is also not maintainable on the simple ground that this offence, whatever it may be against A, B or C, will only be investigated in the area in which it has been committed by the officer in charge of a police station. That is under the BNS and under the old code, Mallards. That can't be per se in law investigated by third parties. That can be done through a court. The reason why I put forward this proposition is, if there is a statutory remedy, that statutory remedy has to be followed. That is the
Yes,
proposition.
yes.
I'm not saying 32 can't, it is on the maintainability of 32. I'm not on the facts. It is a statutory remedy. That statutory remedy has to be followed. You can't invoke 32. 32 article can't be invoked, Mallards. And then,
Yes, yes.
no. So, Malad, the point I'm making is, I am not, Malad, at the moment I'm on the fundamental point, it's not maintainable. So the proposition is not Malad on the allegations. Proposition is, there is a statutory remedy provided. That statutory remedy has to be followed. And once there's a statutory remedy,
Which is that statutory remedy according to you?
that wherever the offence is committed, that police station will have jurisdiction. That's it.
The statutory remedy is 156(3).
Yes, it can be, yes, 156.
Under
First FIR.
Under Sakari Vasu,
First FIR.
FIR
Then if it,
or information to the SP.
correct, then under Sakari.
Then
Yes.
156.
Then 156(3).
If not,
Malad, then somebody, and he can say, he can direct FIR be registered. Right?
if not 200,
Then 200.
200 CRPC.
That's right. Otherwise, 226, 406.
Which is that offense to be investigated under 632?
Sorry.
Which is that offense?
These are
To
offences.
be investigated 632.
These offences. BNS offences. BNS offences. Malad. These are offences under BNS, I hope, Malad. These are not offences under any other statute. These are BNS offences committed in West Bengal, in Calcutta. Now, as your lordship knows, BNS says offences will only be investigated by that police station.
Now, the tenor of your argument is to be the offense of the whole situation.
No, I'm not on situation, I'm on the offences. My argument is 32 doesn't, what is that? I hope I'm making, I am saying 32 doesn't lie. I'm not saying anything else.
All is loud thinking.
Yes,
It's all from your
I know.
loud thinking.
32 doesn't lie is what I'm saying. If there is a statutory remedy available where a particular offence, 32 doesn't lie. That's all I'm saying. Right? Where does 226 lie?
That is fundamental principle.
Yes. And where does 32 lie?
Whether it is
26
Whether
lie?
it is 226 or 32,
Yeah.
if there is a statutory alternative remedy available, these proceedings would not lie. That is the fundamental.
No, I'm not even saying where the offence is committed, that police station has the jurisdiction to investigate that offence. Right, Malas? That offence can't per se be investigated by somebody else till there is a remedy, and that remedy is 226 by the person who is aggrieved. 226. And he can then allege that this can't be investigated here, as my lord put to me.
So you are saying that for statutory violation, 32 will not lie unless it is fundamental right.
Unless it's a
That
fundamental.
is what you are saying.
If it's a fundamental right, Malas, if it's a fundamental right,
Then only 32.
no. Malas, I don't think
You are
that.
fundamental.
No, I'm not saying that, Malas. Once there is a statutory remedy in respect of a criminal offence, Malas, I don't think I can make it clearer. There's a criminal offence committed within a particular area in a particular state. Then under the BNS, that investigation must be done in that state. Even if there's a violation of a fundamental right, it has to be done in that state, Malas.
Yes.
It has to be done in that state, even if there's a violation of a fundamental right.
Yes.
And there are remedies available. You can file a 226, Malas. But Malas, we are going beyond what
No,
I'm arguing.
but-
I'm not arguing that.
This principle applies to 226 also.
Yes.
That if a statutory remedy is available, then 226 is not.
But in this case, the statutory remedy is the commission of an offence and an investigation.
Yes, we have
That's all I'm saying.
We have understood.
Right. And 226 will lie where you say it is not being investigated. If it is being investigated, 226 will not lie.
No, we throw petitions. 226 petition on this ground also that go 156.3, invoke 156.3. Don't ask for a mandamus or registration of FIR.
Right.
Sakiri Vasu.
Right.
Yes.
No, I understand that, Malas. But I am not arguing that point at this point. I am only saying that at this stage, that fundamental right cannot be invoked. Unless there is an investigation and that investigation is not moving forward properly, then only it will be invoked. You can't assume. Cannot assume facts. Malas, for example, Malas, can they say that the state police cannot investigate that offence, Malas?
Yes.
As far as our allegation is concerned, with the commission of offences by them? Therefore, I can also file a 32. Is that the case, Malas? The NCP ECR,
Cases are always interesting.
this one in particular.
No, whichever case.
Kindly see.
Yes.
Let's kindly see third paragraph, third page.
Yes.
So well done. Article 32, this is NCPCR, mothers, moving the court under 32.
Is a vital provision. Yes.
Yes? Article 32 is a vital provision of Part 3 of the Constitution which deals with fundamental rights and is a fundamental right by itself. This court can issue directions or orders or writs, including writs in the nature of habeas corpus mandamus, prohibition, overrun, processual right, whichever may be appropriate for the enforcement of any right conferred by Part 3. Citizens are entitled to appropriate relief under the provisions of 32 whenever there is a violation of any fundamental right. No doubt, when there is a violation of the fundamental right, public interest litigation is also preferred by and on behalf of citizens by public spirited persons, which are also termed as social action litigation. However, we find it strange that a statutory body, such as the petitioner in the instant case, is invoking Article 32 of the Constitution for seeking the aforesaid reliefs. When Article 32 is meant for citizens to enforce their fundamental rights, the said article cannot be the basis to file a writ petition by statutory authorities against the state, union, territory for seeking directions in aid of discharging its functions under the statute. The said article also cannot be the basis for statutory bodies or authorities to seek enforcement of fundamental rights against private citizens. The same is incongruous and not in accordance with what is envisaged under the Constitution. Direct authority on the point. Even if it's a statutory authority. And in this case, well, that's not the case at all, according to us, as I have argued and Mr. Devan has argued. The Directorate of Estates is not a statutory authority. Now, let's kindly come to.
Please concentrate on the fundamental right of the officers of the ED with whom or by whom the offence has been committed.
On that, I have made my.
Otherwise, you will miss the point. Both.
I got it.
If
On
you
that-
only concentrate on ED and forget the second petition,
Correct.
which is preferred by the individual officers
Right.
who are the victim of that offence,
That is problem.
you will be in difficulty, I'm telling you.
That's well as I'm not arguing.
If you argue ED, and don't argue to individuals who are the petitioners in the other petitions,
Right.
then
I was
probably you may
that
miss
is
the
not-
point. That is what we are alerting you.
Argued by someone else, well as I'm not arguing.
Whosoever is arguing, we are telling you. Yes.
What is it?
Now, whosoever is arguing, otherwise,
But in the first petition also, petitioner number 2 is the deputy director.
he was not there on the spot.
Personally,
That is what Mr. Sibal has
he is
said.
an accused in the FIR registered by them. I saw that.
He is an accused.
Yes.
No.
Then he is a better case because if he is not there according to Mr.
In
Sibal.
both the
And
petitioner.
while he is sitting in Delhi and he is made an accused for something.
Accused in what?
Everyone involved in the rape.
Our case which has been stayed, that's all right, Mothers. It's not in their case.
Lord, he was in Calcutta, he was the supervising officer, he was supervising this search. I
He was
come to
not on
that.
the spot. He was not on the spot. He doesn't have a fundamental right. Nobody interfered in his
What
activity.
Mr. Sibal said that P2 Robin Bansal was not at the scene of occurrence.
Yes, he's not there.
It says that I am filing this for the officers of
That's not right, that.
including myself.
I have already told that to the court. You can't be filing a fundamental right petition for others.
Yes.
Basic principle. What have they said? Which person is doing it? But she will answer that because she is in that petition.
Yes, because
Because I'm not in that. What allegation? Because she will not, because I'm not. She will take care of that. But let's kindly come now to, now, mothers, as your lordship said, I told your lordships last time, obstruction of a public servant is an offence under 221 of the BNS. Right, mothers?
yes,
So they have a remedy.
yes.
And that's their right, statutory right at best, mothers. Because it's not a fundamental right. The point I'm making, mothers, none of these are fundamental rights. A person performing a statutory duty, the violation any obstruction in the performance of that duty is not a violation of a fundamental right. Well, for example, a police officer is discharging his function, somebody obstructs him. He can't file a 32 petition. He also can't file a 226 petition. There will be a prosecution launched for violating his right to discharge his functions. So where is the question of 226 or 32 come in? Because there is a statutory remedy. Now you can't say no. We don't have to go through that statutory remedy. I can file a 32. But then every police officer will have a file a 32. A state police officer will file a 32 against them. Then what will happen? So you can't interpret a law in the context of a particular fact situation, and then open a Pandora's box, which will be inconsistent with the basic features of the Constitution as well as the basic features of criminal law. So, ultimately, it boils down to this: a person performing his statutory duties, if he is interrupted in the performance of those duties, then per se there is a violation of a fundamental right.
Yes.
That's the proposition, probably by the other side. That's a proposition which, with the greatest respect, cannot be accepted, because a person has no fundamental right to investigate. He has only a fundamental right. He has only a right under a statute to investigate, and a violation of that right is not a violation of his fundamental right.
Yes.
Right. Now, kindly see the verments in ground ZZ models. Page 41.
Page
41. Because false, frivolous, and retaliatory FIRs were deliberately registered against ED officers, not on account of any unlawful conduct, but solely with the object of criminally intimidating them, browbeating the investigating agency, and deterring the performance of statutory functions under PMLA, which is the teeth of Article 14, as well as Article 21. Where does Article 14 or 21 come in here, Manas? If the allegation is that they have committed offences, Manas, how does Article 14 and 21 come in? Guarantees free and fair investigation by investigating agencies. How does that 21 come in? Then let's kindly see grounds AA at page 27.
page 27.
27. Ground AA. Because the search and seizure operations conducted by officers of the Enforcement Directorate were lawfully authorized under 17, pursuant to reasons to believe. Right, brothers? So therefore, that they are exercising their statutory right. Now kindly come to DD, page 28. Because the acts of wrongful restraint and confinement of ED officers, possible removal of digital devices, disruption and intimidation during such collectively amount to frustration of statutory powers. They are not talking of fundamental rights. It is their own case, brothers, that they were exercising their statutory powers which are frustrated. Which is that fundamental right that is violated? That's why 221 of BNS. Then when there's GG at the bottom of 28, because section 67 of PMLA, protection of action taken in good faith, provides that no suit, prosecution, or other legal proceedings shall lie against any officer for anything done or intended to be done in good faith. Because the ED officers were acting strictly in discharge of statutory duties. There it is. Then page 43. It is their own case, brothers. Triple L, brothers, at page 43.
Yes.
For that, the facts disclose direct involvement of highest political executive, abuse of police power, theft and manipulation. That this honorable court has consistently held that where high and mighty states are involved in commission of cognizable offences, investigation ought to be transferred to CBI. This is now, they are going beyond the fundamental rights issue.
Mhm.
So, the petition, the argument before your lordships is, it is their own case that in the discharge of their statutory duties, certain offences under the BNS were committed. Others, that is not the basis of a fundamental right, can't be that. Others. And the PMLA itself demonstrates others, that powers flow from the statute, not any provision of the Constitution. Powers don't flow from 21, don't flow from 14, don't flow from 19. They flow from the statute itself, whether it's the CBI or it's NDPS or any other statute. They flow from the statute. A violation of the statutory exercise of power is not a violation of a fundamental right. As a matter of law, it can't be. Now, I read to your lordships the other day, and I don't want to repeat it, just to show 49, your lordships will remember 48 and 49 of PMLA,
Yes,
so that we are clear on what the submission.
48 and 49.
48 and 49.
Yes.
49 says, the central government may appoint such officers as it thinks fit to be authorities for the purposes of this act. Right, Mullahs? And there shall be the following classes of authorities. So the authorities are appointed by the central government. That goes to the first proposition that I will address your lordships on.
Yes, yes.
Having been appointed by the central government, the Directorate of Estates can't have a fundamental right. The aggrieved party is the central government. And the central government can't file a 32 petition, as I mentioned to your lordships. Nor can the central government file a 226. The individual Mullahs certainly can file whatever he wants to file, but that individual can only go under BNS 221. Because he's being obstructed. He has no fundamental right. He is claiming it as an officer of the ED, not in any other capacity. I can understand if he claimed it as an individual, but not in any other capacity. Because he is saying, even in the other petition, it's the same. He's only claiming it as an officer of ED. So where is the question of a fundamental right here? Because the moment your lordships were to even lay down that law, then every officer in discharge of his, it may be customs, it may be any officer. The moment he is obstructed, he is a violation of his fundamental right. That, with respect, would not be a proper enunciation of the law. Then, now let's kindly see, very interesting here. But before I go to that, a more fundamental issue. When is a fundamental right, when can a fundamental right be invoked? Basic principles. When it is being violated. A fundamental right cannot be invoked when the alleged offence is already committed. As a matter of law.
Yes.
Whereas I am forcibly kidnapped by somebody. My wife goes to court and says, look, I want to file a petition. My husband has been kidnapped by somebody. It's fundamental, and he continues to be kidnapped. Petition will lie. But if he is kidnapped and he is released, and then she invokes Article 226 or 32, petition won't lie. In Sonam Wangchu, for example, he was released. It was dismissed as infructuous. Why? Because the fundamental right doesn't inure to his benefit anymore. So all these allegations are made with what happened in the past. So how do you invoke a fundamental right? In respect of incidents that have taken place. You can only invoke your powers that look, an offense has been committed and therefore proceed in the matter under 221. There is no existing fundamental right today at the time when the petition is filed. This is a fundamental issue, Manoj, that your office will have to decide.
For that only we are hearing.
No, I'm making the propositions.
Yes, yes.
Fundamentally,
Okay.
the propositions that I'm addressing also.
Yes.
It has to be an existing fundamental.
Yes, it should be a continuing violation of a fundamental
That's
right.
right. Then only it will be invoked.
So that we invoke or issue the writ.
Exactly.
Continue.